Afternoon, everyone. Pleasure to be here. And sorry for the 2-minute delay on the panel, I believe. Clock's ticking, so I guess we're on time. So we have one of the most interesting topics here today on the elephant in the room, which is artificial intelligence. For everyone, I think everyone in this room is using AI. Is there anyone who's not using AI? Great, then we've got a room full of answers and questions in that way. So I know we all should consider ourselves very fortunate because we are sitting at a milestone in the history of law and regulation, where we have a massive change coming in the whole landscape of not only how regulations are made, but also how they are interpreted and also how they're becoming applicable. Artificial intelligence is the new age that we've entered in as professionals, as people, and it's touching all lives. As we say, it's got the largest market touch. However, with the coming in of the Personal Data Protection Act and the government aligning towards artificial intelligence guidelines, the DPIIT coming out with the the AI and copyright working paper, are all giving us inclinations as to how we will see our way forward in this very interesting times. Now, the personal data is, as we say, we are living up on the grace period for the same, where the applicability begins next year. And we have the penalties imposing are very clear. They're telling us either all the technology companies to obviously either align or be subject to the heavy penalties which rise up to 250 crores per instance. So it is not even dependent on your revenue, unlike the other jurisdictions such as the GDPR and EU GDPR. Clearly analyzing the fact that we are taking our own stand as a country on the technology laws and how we're going to deal with them. So we have got a very interesting panel here with, to quickly introduce myself, I'm Shivaarti Bajaj, we've got Dr. Duggal here, Lakshmi, and we've also got Pulkit. So I think I'll leave everyone to introduce themselves if they want to. But Dr. Duggal, of course, is an illuminary in this field. He practices with the Supreme Court of India. Lakshmi is with the GC with the HCL. And we've got Pulkit, who's with a Russian bank. So, so yeah, I think the bank is SBERBANK, right? So yeah. So we will start with Dr. Duggal first. Dr. Duggal, pleasure to be in conversation with you again. Your thoughts would primarily, I would want that, India is undergoing a transformative period from a regulatory perspective with the introduction of DPDP Act and rules, and with several perspective of plans for the AI regulation. How do you see this with a direct intervention of DPDP and AI in isolation?
Thank you, Shivaarti. The question is, today, DPDP Act, without becoming implemented, is already becoming portion of it as obsolete. Why? Because when they passed it in 11th of August 2023, they didn't think of AI. Today, AI is becoming a big data fiduciary because AI is taking the decision how my data as a data person is going to be, data principal is going to be taken. Yes, I can still apply the principal-agent relationship to say, well, I am the principal, I am invoking AI, so if my AI use is wrong, I'm going to be liable. Either way, the fact of the matter is the fire below my seat has already started. Whether I'm beginning to feel it or not is of no consequence because the fire is still there. I'm waiting for 13th of November 2026. That's the day when the exposure starts. Why? Because that's the day your potential complaints could potentially start coming in. Therefore, if you are in the mindset that we all love in India cricket lovers, and we all have one utopian common dream, that we can all hit 6 sixes on the last 6 balls of the T20 match. I think that never happens. So if you think you want to be hitting your 6 sixes on last 6 balls, that's not going to happen at all. And the problem is, if you want to do jugaad may not necessarily work in the DPDP context. Therefore, how you are going and invoking AI in your day-to-day operations, you will have to be mindful of the fact that the AI also complies broadly with the parameters of the DPDP. It's a very transformative space, as she rightly talked about. But the next 1 year should also be the space where we should see a lot of movements in the form of more clarifications from the government to say how you need to be dealing with these things. There are a lot of grey zones yet. People are clueless. And as far as AI is concerned, the elephant in the room is not being addressed by any stakeholder. Look at the European Union AI Act. Look at the Chinese AI laws. Look at South Korea's law on AI. Look at El Salvador's new legislation on AI. Now look at Japan's new Basic AI Act or Hungarian law. Everybody is like the 5 blind men who are trying to describe an elephant. Nobody is dealing with the fundamental issue, will AI be granted legal personhood? Well, I'm very clear that very quickly you'll have to start granting a conditional personhood and finally full personhood to AI. Why? Because AI today has begun at that level where the cognitive intelligence is more than a PhD scholar or a PhD researcher. And only hold on, this is just narrow AI. Agentic AI, a typical agentic AI agent is able to do one particular task 500 times more efficient than humans. And now with the AGI coming in and ultimately super intelligence, I think corporate sectors will have to be prepared. The laws is much, much behind. Well, the government is now beginning to wake up as far as AI is concerned. But the government is saying, I'm very clear. More innovation, less regulation. I don't want innovation to be hindered. Wonderful. The only problem is that the misuse of AI is beginning to catch up in a big way. Go to Darknet this morning, and the only version, or shall I say the predominant model that's available there is cybercrime as a service powered by artificial intelligence. Cyber criminals know we don't want to dirty our hands. Let's use AI for the purposes of going ahead and doing illegal activities. So corporates, legal stakeholders, DPDP ecosystem stakeholders will have to wake up, start tightening their belts. A lot of people are saying, hold on, let's not go ahead and do it, let's wait on. हो सकता है कुछ relaxation आ जाएगी, देख लेते हैं. Let's try to look at next September, October. I think that's a bit too late. Begin to start having your own preparedness levels in terms of where you currently stand vis-a-vis your preparedness for DPDP. Look at how you are doing your compliances under the IT Act, the IT Rules 2021, the IT Directions 2022, because all these are ultimately marrying down into a huge mesh of regulation. And the problem is, people still don't believe that they could potentially be facing 250 crores. Well, why? Because the argument is 250 crores is the maximum fine available. So I'm not going to get the maximum fine. Don't worry, gentlemen. The fact still remains is, if you get fined, your fine starts at 50 crore rupees. Yes, after 50 crores, the Data Protection Board has got some discretion whether to grant you anything between 50 and 250 crores. But the fundamental issue is, what most of the people are forgetting, is that DPDP Act is a draconian legislation. Why? Because this money will not go to any private complainant. It goes to Government of India. It goes in the form of payment to Consolidated Fund of India. And should you say, sir, I don't have money, the government says, go back, no problem, sit back and relax. We consider this as areas of land revenue. So I'm going to attach the properties of the company. If that falls short, no problem. I now have the ability to attach the assets of the top management. So suddenly now top management has to be more careful that they must try to get the more compliances and more documentation in place. Why? Because if they don't do that, the ultimate exposure could be to the personal assets of the top management, which is unheard of. Of course, people have not even begun thinking in that direction because, we as Indians always wake up in the last moment. But I believe the time has come. It's a transformed world. Meanwhile, with this new approach, this new working paper on copyright, we are already beginning to see diversions, differences. A NASSCOM does a 25-page dissent note to this particular working paper. Why? Because they think it's going to have a prejudicial impact, rightfully so, on the industry. And if you are one of these small content creators, be prepared to be marginalized because it will be consolidation of the big few, the big tech, versus marginalization of the smaller and the medium content creators. So very interesting times. All I'll have to say is, you have to tell everybody in your ecosystem, please don't reduce things into writing. Whatever you do, don't reduce into writing. Why? Because the moment a personal data breach takes place, two triggers trigger off. Number one, within 6 hours of my coming to know about it, I have to report it to the Computer Emergency Response Team of India. I don't report it, no problem. After 6 hours, I commit an offense, punishable with imprisonment and fine, Section 70B6 of the IT Act. But that's one exposure. The second exposure is within the next 72 hours, from the time I come to know of the attack or the personal data breach, I am required to give a detailed report to the Data Protection Board. The moment I don't do that, that is also non-contravention. That's also contravention. That's contravention. The 250 crores also potentially start sinking in. So I think we are going to see a tsunami of complaints against corporations, against entities, should they not be compliant. So I think the only way forward is compliance. That's the only nirvana going forward, but it's a transformative stuff. We have to realize that our journey has begun. We are already riding a running tiger, and we do not have the ability to get out the tiger. Therefore, we'll have to go ahead and calibrate our approaches and strategies as we move forward. Thanks.
Absolutely, thank you, sir. Yes, we are actually running a very aggressive tiger, right now. And to add to it, I'd like to move to Lakshmi, stating that with the advent of, not the advent exactly, but the coming up of the working paper on AI and copyright, which is directly affecting, and in fact, it is trying to put a policy on one nation, one license. That in short means that there is a question of dealing with fair use that has been a very big hinging point for all copyright matters in India up till now, in terms of dealing it on a more monetary and statutory aspect. So when we are talking about AI and an amalgamation with intellectual property rights in terms of ownership, the biggest question that we have now is who owns your data? Is it the creator, the person who put the prompt, the company, or some third-party vendor? The output ownership is something that is a very big question mark in the ecosystem right now. So Lakshmi, I'd like your thoughts on the intermingling of IP, DP, and the advent of AI in terms of ownership and in terms of the law and regulation. How do you think it stands and it evolves? Thank you.
Yeah, thanks Shivaarti, and good afternoon everybody. I'll first probably address the question around AI and copyrights. In most jurisdictions, any AI content or any AI output is not treated as copyrightable because there has to be some sort of significant human input. And obviously that would entail things like skills, judgment, intellect. So unless that is demonstrable and very evident, any AI generated output would not be treated as a standalone copyrightable piece of work. Some of the jurisdictions, interestingly, which actually recognize potential copyrightable work which is generated through AI is China, because China believes that if they are able to show that even the AI content or the AI generated output has certain features of intelligence, can function on its own, then that would be given copyrightable status. What's also interesting is countries like Australia, the US, India, we are countries or jurisdictions that clearly believe that copyrightable works have to have human intervention, it has to have human creativity, but there are jurisdictions like the UK where they're clearly also looking at the potential of recognizing AI-generated content as standalone copyrightable work. What's fascinating is in order for AI to be recognized as a standalone copyrightable work is it should have, features which are very identical to human intelligence. And the other fairly fascinating thing which I came across when I was going through this piece was any sort of copyrightable work which has any AI input, if it is merely used as a tool, it can gain copyright status. However, if it is a standalone work or if it is completely operational without any sort of human input, that will not be treated as copyrightable. So even when, like for instance, a person who's an AI developer is using, say, some sort of an AI tool to edit content or to carry out some other sort of work to embellish some literature or something that they're working on, that will be treated as something which is capable of being copyrightable. So, so when it comes to copyright and IP and AI, there definitely has to be human oversight, human in the loop, human intervention, because it's quite clear that without that level of intervention, these works would not be treated as original. On the point that you made regarding accountability, especially when you drew reference to the AI, the METI guidelines. So the METI guidelines are a very interesting set of guidelines which are basically anchored in 7 principles. And one of the 7 principles is accountability. So the other principles are, do not cause harm, keeping the human in the loop, fairness, transparency. But I think one of the most critical pieces of the guideline is the accountability element. And that also ties in with the copyright related debate, because when AI is created in an accountable fashion, and by the way, when the people who create any sort of AI output, it's not a single person. So most of us have this misnotion, or it's like almost to the point of dystopia, that when you create any sort of AI content, it's only someone who's a technologist or someone who has some coding capabilities who's able to create it. But actual content creators of AI are people who span across an entire spectrum. So it's people from the leadership team of that company. It includes C-suite executives. It includes people from legal, from compliance. And why that's important is because you need a broad spectrum of professionals to help develop robust frameworks so that AI is generated and produced and created in a responsible fashion. So responsible and fair use is so important and critical to the entire dialogue when it comes to accountability. And some of the companies that have really aced the principles of responsible use or secure use are companies like Google, for instance. They have principles rooted in explainable AI. Or you take Anthropic, for instance. They are very focused on building AI platforms which are again rooted in safety. You have IBM, which is the creator of Watson, which again is very rooted in the principles of responsible AI. So these are some of the companies that have really got it right. There's a German company by the name Validator, and this company actually creates certain solutions which are used to develop accountable and robust AI frameworks. Why is creating a robust AI framework important? It's important because your regulatory framework and this AI framework or accountability framework that you're creating need to merge. They need to talk to each other. Because if it doesn't talk to each other, that's when there is a greater possibility or there's a greater susceptibility for AI-caused harm, right? And interestingly, harm that's caused by AI cannot be easily redressed by AI. Right? So therefore, I would just want to conclude this particular point by saying that creating accountability in developing AI is no longer optional. It's absolutely essential. And either companies that are involved in the business of creating AI or businesses that are involved in purchasing or consuming or if you're a user of AI, it's so important to understand that you don't buy something which is not explainable. You don't buy something which is non-transparent. You buy something where the AI actually is clear. It's able to explain itself. It's not like a sandbox or a black box where you cannot figure out what's really going on, because it has independent decision-making capabilities, and you need to understand that. So that's why it's really important when you have this conversation or when you're looking at investing in AI, using AI, always take a moment to understand if that tool that you're using, are they deploying responsible and secure use principles, or are they just blatantly selling a product to you without revealing what's really happening in the background?
What we need to appreciate here is that the not laws as such as of now, but the guidelines are clearly hinting towards a very important aspect, which are also highlighted in the AI regulation guidelines released by MeitY, is privacy has to be built in the design of the product. So privacy by design is something that has been a very front runner in terms of the messaging explained to everyone through the guidelines. And the second aspect that has really come through is that who owns what, who created what. When we think of that, we only think of probably a tree or a flower or some other object in terms of creativity, but IP goes way deeper. It goes up to the inventions that have been made by very learned inventors. It goes up to be deep fake or misuse of cross brands being created by a lot of entrepreneurs. It goes up to the fact of the multiple designs that are important and have been filed in the ecosystem and are owned by various brands and creators. So these are the very, very strong lines that are being crossed with the advent of AI and with the, of course, the built up of the Personal Data Protection Act, Pulkit. I'd like to take your thoughts on how, when one is building and the role of personal data in a company in terms of it being inherently incorporated going forward as a design factor to build on privacy by design. Yeah.
Thank you for that question, Shivaarti, and very good afternoon to all the ladies and gentlemen present here. So I would say that AI is relatively new concept as compared to data privacy. And in terms of building it and its deployment in, you can say, the organizational infrastructure, its intersection with data privacy is something which is very much technical in nature. And on the data privacy side, we already have the concept of privacy by design. We do have certain principles governing it. And I guess this is the roadmap that every AI developer should focus upon. From Indian regime, I would say that DPDP is something which is not actively covering AI per se, because there is no mention of AI there. And that is something that our government should proactively work upon. And while we were sitting here and we were listening to insights of our honorable members of the legal forum, one of the members of the parliament has introduced a bill related to AI and its accountability. And taking into consideration, so I would just like to mention that DPDP is not covering AI per se, but whenever you are incorporating any kind of personal data into your AI system like LLM models or maybe the chatbots, at that particular instance, the DPDP Act gets triggered, because you are governing your AI model on the basis of personal data, and which is very well covered comprehensively under the DPDP Act. Now, privacy by design is something, even though which is not, you can say, recognized by our Indian legal regime, but this is something which is a global principle and that should be very well incorporated, and it works on the best industry practices.
Also, if you could just highlight it along with the DPDP Act in terms of amalgamating the two.
Sure. In terms of DPDP Act, I would say that it's still a very new legislation. It's like a newborn baby which will develop over a time, and we might see a lot of amendments in it, and we might see AI being an integral part of DPDPA framework, and we might see a comprehensive legislation in the future, so that such kind of principles are not only applicable to the organization in terms of best standards only, but rather as a regulatory mandate. So these are my broad, you can say, conclusions on this. And comparing it with the GDPR, so under the GDPR, we have some of the rights pertaining to use of AI by the organization. So we have the right to restrict the processing based upon AI. And we don't have anything as such in the Indian regime as of now. So I would say that there should always be a kind of human intervention whenever any kind of personal data is being processed entirely through AI. And we should have such kind of principles in place. To conclude, I would say that implementing the AI models is like, in terms of GDPR, it's like operating a flight wherein a trained pilot is allowed to retain the control. From DPDP perspective, it's that the pilot is entirely responsible whether you are opting for an autopilot mode or not. So this is a brief, yes, please.
So Pulkit, when I read the DPDP Act, one of the things that stood out, especially around AI, was the fact that all these AI developers are now going to be clearly covered, and they would have to follow the principles and the obligations under the Act, because there are three distinct areas where I see that they are going to be governed. One is all AI, be it content creators or developers, they would have to start following the consent process. So consent becomes somewhere king, and they will, in order to develop any sort of AI training modules, they cannot collect or collate data without obtaining consent. So this is probably the first attempt at really regulating, I would say, AI users, AI developers, AI processors. They also become data fiduciaries. And by virtue of that, it's like it's literally like putting a leash or a rein on them, because all this while, all the AI developers who went out and were involved in data scraping or unauthorizedly mining data, they are all now on a leash. And clearly, they're not going to be very happy about it, because there's a cost to that compliance, like Sir said some time back. So the second aspect is accountability, because now they are data fiduciaries. And the third aspect is the data subjects, or the users, whose data they're going to collate and use and process. Those folks now have a right. So earlier, though they were voiceless, right, data users. But now data users are going to have a clear voice, the right to erasure of data, right to amend their data. So obviously, AI developers, users, as well as processors, are not in a very comfortable spot right now with the new DPDP Act. That's how I see it.
Right, thank you. I think we'll have to conclude. So I'll just quickly take concluding remarks from everyone. And now, since we are at a very gathering of lawyers, everybody from the legal field, I have a question for everyone to include in their concluding remarks. Dr. Duggal, what is the one clause that you would say is imperative for all contracts going forward to be included as an aspect keeping in light today's discussion?
The master clause will have to be compliance with DPDP will have to be done by me and by my outsourced vendor or service provider, be that as it may. Now, both of us are in the same boat. My responsibility is not going to be adjudicated solely on my basis. I will have to be responsible for that. So get your terms very, very crystal clearly defined. Revisit all your contracts without any exception, and make sure that there are appropriate standard addendums to the contracts whereby your legal interest under the DPDP Act could be protected.
a aspect of any clauses that you feel are imperative going forward in all contracts? Yes.
I think it will become very important to look at the liability and indemnity clauses, because DPDP being a law, I think more vendors are going to push very hard to have very broad indemnities. So clearly that is something for all customers, for customers to look, for vendors to look out for. So they're going to have a tough time negotiating that, especially because there are clear thresholds and limits also prescribed by the Act. Yeah. And another very important thing, not from a contracting perspective, but I think it's very important for all of us lawyers to ensure that your board, the board of directors, if you're working as an in-house lawyer, ensure that the board is appropriately briefed, because any failure to apprise the board when there's a data protection breach will also result in a penalty of 200 CR. I think that's the second highest penalty that's been prescribed in the Act.
Thank you. To conclude my remarks, I would say that I totally concur with the insights of the panel members. Apart from that, I just want to conclude by saying that data privacy is something which is not a one-person game and should not be entirely dependent upon the data protection officer or the privacy council of the organization. Rather, it has to be, you can say, a game of all the individuals participating in the daily affairs of an organization, be it CEO, be it the operations team, be it HR, be it the CRM team. So I would say that it more of a culture-based game that will, I would say, proactively shape up the regime, the privacy or the AI regime that our economy is heading towards. So by that, I'll conclude the remarks. Thank you.
Thank you. Thank you, everyone. Let's see how this interesting times proceed with the advent of data fiduciaries, personal data, data processors, and everything being taken over by AI and regulation. I think we're going to witness very interesting times ahead, both in the courts, on contracts, and in our daily use. Thank you, everyone. And thank you, Team BW.